like before beginning with the session, it's a request to everyone, like whosoever wants to speak, so they can like first of all write their query in the chat box, so we will get an idea what, because it will be no, then creating unnecessarily chaos in the meeting. So if you are having any sort of doubts or whatever your queries are, you just type in the chat box, and accordingly, like I'll be engaging them one by one. Okay, so the webinar for today is basically on the legal research and writing. And as you might be aware about the speaker who is going to attend this, like she is, the name of the speaker is Miss Pooja Tiwari. And so, like briefly talking about the speaker's resume. So it is Pooja Tiwari. She is a research analyst with a leading global consulting firm, brings an extensive experience from renowned institutions like National Law University Delhi and OP Jindal Global Law School. Her qualifications include an LLM in corporate and commercial laws and a master's in gender and development studies. And also, Pooja is a certified POS trainer. So, and beginning with today's session, so I would like to request you all, whatever, like, you just hold on till the end of the session one by one. And yeah, like, and even keep a check on your mics, that because it will be creating and disturbing our speaker in between the session. So, kind cooperation is expected from each and everyone. So, okay, so without wasting time, I would like to invite the speaker to begin with today's session now.
Hello, thank you for having me. Am I audible?
Yes, ma'am, you are.
Yeah, I would also request you to kindly give me the rights to share the screen. I would like to open up a PPT.
तुला आवडलं असतं म्हणलं आपण घेतलेलं कसं नाही
घेतलं तुम्हाला
Someone's camera is on. Can you please cooperate and
नाही मला ड्रेस घेतलं मला स्वेटर घेतलं स्वेटर
excuse me.
आलायला
पुरा साड्या ते बिलेस असतं
Participants are requested to kindly keep their mics on mute. Hi, is my voice
Ma'am,
not
everyone's
audible?
mic is on, so you can start. Ma'am, it's audible.
Yeah, I just wanted to request that if I could share the, okay, I can share the screen now. Let me know when the screen is visible.
Yes, ma'am.
It is visible.
Okay. Thank you, everyone. First of all, a very good evening and a happy new year to all 40 of you who have gathered here for a session on Introduction to Legal Research and Writing. So basically in this session, I would try to give you a brief about and a head start onto how to conduct a legal research, and thereafter how to do a legal writing or how to undertake a legal writing. So during this 1 hour engaging session, we'll be having a brief overview upon what is research. And thereafter, we'll also dwell into what is legal research, what is its relevance and importance. I've tried to keep the topic very engaging so that you and I could actually connect at a level, because most of you come from a legal background, and research is such a basic and a first element of our career, or in any field that we are in. We will get on board to look for anything, and that's when the research aspect comes into play. So I'll try to connect on that aspect, and moving forward we learn that how legal research is relevant and important. Thereafter, we'll also look into what are the different types of legal research. Then we'll look into what are the nuances of legal writing, what are the different sources from which we can gather information, and we'll also look into a format of an ideal research report. So during this course, there are a few learning outcomes that each participants can expect. Those include that they will be able to apply the convention of effective legal writing moving forward by the understanding of a few aspects that we discuss upon during the session. You'll be able to develop legal analytical skills. You will be able to gauge yourself in creating a memo that will be based out of legal problems. You will have an understanding of how to draft an email or a legal letter that is a little different from the basic English letter that we write. We'll be able to apply IRAC method. An IRAC method is when a case or an issue is in front of you and you dwell into what is the main root problem of the entire scenario, what is the application of rule that comes into play. Thereafter, you analyze the solution and thereafter you come to a conclusion. So by the understanding of how to conduct legal research, you will be able to look properly into those different nuances and will be able to apply the skill that you gain here moving forward. So you'll be also gaining, as discussed before, you will be also gaining a few legal research skills and techniques. Mid-session, we have a test series which will help you brainstorm how to conduct legal research, and thereafter, we also have a research report format. So that also gives you a first-hand understanding of what are the legal research aspects. We'll be also able to identify a few ethics that are necessary to undertake issues of legal research. That includes plagiarism, what are the particulars with regard to citation and referencing, and how wrong it is to misrepresent a writing. So when you hear the word research, which we're here to talk about, what is the first thing that comes to your mind? Is what about it? Like what it is? What is research? So the term basically was derived from a French word that meant to search. The word was recherche, and which meant to search. So the term itself states that research means looking for anything. And when you go by a word-by-word analysis of the term, it goes like R stands for rational way of thinking, E stands for exhaustive treatment, S stands for search for solutions, E stands for exactness, A stands for analytical analysis of adequate data, R stands for relationship between facts and theories, and C stands for constructive attitude, and H stands for honesty and hard work in all aspects. So if in a layman term, I have to define research is, it is with a rational way of thinking. If you go out to look for a solution with a very constructive attitude and a critical observation, you're actually willing, you have a query or you are inquisitive to learn more about something, you go forward with one attitude of exploration, and thereafter you delve into its explanations, and thereafter you dwell into or conduct an in-depth understanding of a particular notion that you hold. So now that we've understood what is research, this second core aspect of it is legal research. So many a time we tend to presume that research and legal research are synonymous to each other. However, that's not really the case here. Research is when you go out to look for something, but legal research is differentiated how it, because legal when you conduct a legal research, you conduct a systematic investigation. You have facts in your hand, but now what you're doing is to establish or to negate those facts, you undertake a systematic investigation. And after conducting that investigation, you come to a conclusion. Either that may corroborate your fact or it may decline it. So legal research is different than researching. Researching is basic, that you go online, you want to know, let's say I want to know about what were the best hospitals around me. So I go online, I get a list of data that may help me in one way or the other. But legal research is more directed. I would go online, I would I would have a systematic approach in undertaking or establishing the facts by virtue of the research that I undertake, and then I reach a conclusion. So it's a very thought through process, and a very I would say all steps have to be explored and dwelled well with the notion that you had in the start. So legal research is a process wherein you identify or retrieve an information that is necessary to support a legal decision making. So because it is primarily undertaken to support a legal decision making, its approach is also very different. As we were talking before, that in general research, we just have a query in the mind and we go to look for it. What is the answer of it? But in legal research, we undertake a systematic approach and we establish a fact. And that we do in order to support a legal decision making. So it's very different than other disciplines. In fact, legal research is oftenly used to establish or substantiate history or sociology. Many a times, historians and sociologists, what they tend to do is, in order to establish one of their hypotheses, they base their judgments on the legal sources. So that may be writings, or that may be an order that was in play. So that research that is undertaken, that also is the legal research aspect that they have gone through. So we've understood, sorry, what is research, what is legal research, and what is the purpose that we undertake a research. The purpose of a research all along, as we've been talking about, is we are curious, we want to explore anything, we go online, we look for another dimensions, another definitions that are there, we look for its explanation. Therefore, thereafter we have our own conclusion and we describe it descriptively or in whichever manner that we may befit. Now we've learned that, okay, this is how you undertake research. But why is legal research very pertinent? Other than we know that it is necessary to support legal decision making, but why exactly it is relevant? We could, just quote cases and, just anything that's very similar to the dimension, because we could just put that through. However, legal research become relevant because in law there are a lot of vacuums that can be filled in when there is a proper directed or a well undertaken in-depth research and process. So legal research become relevant when you have to understand right from the start, like when you want to understand what a law is, right from that scenario, right from that stage, your legal research is very relevant. So once you want to get started today, you want to know that are there any, if I break a traffic signal today, are there any law that is applicable? So you have a legal scenario in your mind. Now you are undertaking a research to understand what is the existent law. That process is the legal research that you're undertaking. All right. Now, let's say, now we'll proceed with the same example. You're aware that, okay, now we know that there are traffic related laws. Now moving forward, next question that comes to our mind is, okay, so previously there was a law that controlled movement of vehicles by odd and even. So is it existent or not? Okay. Even when you want to dwell deeper into the existent legal scenario, even then legal research comes into play, either through the primary sources or secondary sources. It helps you ensure that there is coherence, there is consistency, or there is a stability of law. Whether a particular law is in play or not, that stability can be realized when you undertake a legal research. Other than that, it also helps you point out any ambiguity or weakness that may be existent in the existing law. Like recently, the Indian Penal Code or the Code of Criminal Procedure or Evidence Act people understood by the virtue of legal research over the span of time, it was realized that the laws needed to be refurbished to an extent, or there are certain aspects of the law that needs to be reconsidered, and with that examination, new set of laws were introduced. So that this has also helped in a great extent to conduct a social audit of the existing law and thereafter come forward with the reform. So by virtue of these 4 points, we can clearly understand that how relevant the legal research is. Now that we've understood what is the relevance of the legal research, it is also important to wrap our heads around that, okay, we know that legal research is the process to understand a law. Now we know that, okay, that is why it is relevant. Now, why is it important? Why is undertaking legal research so important? So to best of my understanding, and to make this session very engaging and light, because so that it actually is easy for each one of you to grab, I've tried to give a few relevant importance that legal research holds. So first primary importance will be that legal research helps evaluate the impact of law on society. Once you know that there is a law in play, obviously it's impacting people at large. So the legal research become important because it helps in the evaluation of what is the level of impact it is having at the society at large. Thereafter, it also helps in evaluating what legal system may assist for the social welfare challenges. Hypothetically, you're standing for child rights, and now legal research would help you in evaluating what is the current scenario for child rights, how exactly you will be positioned to assist further, and what is the way forward. So all that process can be brought into action by undertaking legal research. So this makes legal research very pertinent and critical for law reforms. So these are the few importance that I thought would be associating for each one of you, no matter what year of law you're in. Now, moving forward, I have a few tests for all the participants that are here with us today. It's a very easy and understandable test. I just want each one to be engaging. So I thought maybe if one of you could just unmute yourself and answer one by one for each of the questions that I enlist. So I'll go now. The first question is, how can I get started with my research? So by the session so far, what have you learned that how can you get started with research? If any one of you can unmute the mic and give me the answer. Anyone?
Good evening, ma'am.
Hi,
As of my point of view, that the first step for research is to choose the topic which we want to do a research on.
Very, very, very good, Satya. It's a absolutely right answer. So I believe you've been listening me. So thank you. That's the right answer. Next question is, name 2 legal databases. Any 2 legal databases that you know of, you've heard of in your law school, or you've used it while preparing your assignments or preparing for your
Live law
classes.
and SSC.
Hi, Joydeep. Please unmute yourself.
Live law and SSC.
Sorry?
Live law and SSC. SSC
Very
online.
good. Very good. Very good, Joydeep. You're absolutely right. So these are the 2 databases. Live law, I think you have some limit for its access. It's not a free database though. However, it definitely gives you a understanding, to whatever extent you can access it. So yes, definitely that. My next question is, name 2 free legal research resources. Anybody?
Ma'am, the books.
Sorry, Joydeep, you little louder,
Ma'am,
please.
the books. The books.
The book and
And I think so. The books only, ma'am.
the book only.
Books which
Okay.
are kept in the law library.
Yeah, yeah. The law
That is, I think so,
libraries.
free legal research resources.
Yeah, yeah. So very good, Joydeep. Very good. I'm pretty sure you're undertaking good research, legal research. So that's how you know so many of these. So yes, if you ever go online and you're looking for free legal resources that my institution does not has access to so many databases. So how do I go and look up for a book or an article? So all these big universities like Harvard, Oxford, they have their libraries, and you can have an NUS as well, which has free access. You can just go online, you can just log in, create an ID. Not all the books are accessible, but some of them definitely will help you, get a hang of what they have. Other than that, in India, I have, I think, Law Seekho and Loctopus also now, they have a few articles. Knowledge Teas, it's one of the platform that post a few articles that may help you get a head start of, or have an understanding of what a particular topic is. So please go online and explore these, and you can always reach back if you have any query. Okay, so this is a very general question. Where can I go and find the definition of abeyance? Anybody? Just practical application of mind. What, even if right now you have to look for the term, what will you do? Anybody?
Google search.
Yes,
Dictionary, ma'am.
yeah. Anywhere you would go and look for it. So this basically, I put in this question to make you realize that research is to search. So if you have a term like I think Satya answered the first question. When you want to get started with your research, what you do is you go look for it. You are curious, you're looking for it. Okay, now the last question: how can I improve my Google Scholar search? I tried to keep it in a manner so that it also the session also helps you moving forward. So yeah, how do you think can improve your Google Scholar search? Anybody? Okay, so I will help you with this. So basically, the idea here was, what should you do in order to get best of the results of what you're looking for? Okay, so I'll give you a few ideas that has helped me in my 4 professional year in legal research. So what you do is, let's say you're looking for what are the child right laws in India or in Australia. Okay, or we're comparing child rights in India and Australia. Let's presume that's the situation here. Okay, so now if you have to go online and you want best of the articles available or best of the law regulation that's there, what you do is always use your terms in inverted commas. Let's say you're trying to look for child rights India, put child rights in inverted commas. Okay, child rights, whatever, caps on, caps not on, up to you. Put them in inverted comma, use a addition sign in between, and thereafter you write India or you write Australia. I know there are so many AI tools that are extremely helpful nowadays, but other than that, a lot of manual labor is also required, because a few of text are not accessible to these AI tools. However, when you are actually undertaking the research, you can through and through reach there. So using these a few tactics may help you in getting good searches. So use inverted commas, and also try to use addition signs in between the terms that you put in. Okay. So thank you all for actively participating. That actually shows that you are listening. So yeah, thank you so much. Now we'll progress with our session here. We've understood what is research. We've understood what is legal research, how exactly it is relevant, and that we know that it's relevant. Why is it important? So moving forward, we've understood what, when, how, where, why of legal research. Now, the second question that comes to our mind is, what are the different types of undertaking legal research? Because, you know, your query could be anything. Let's say I have a query of what are the laws for eating chewing gum in the country. Hypothetically, there is no law only for it. So now, will I investigate for it or I look for it? So what will that legal research be called as? And if I'm actually coming across a few writings or an articles, then what does that research is termed as? So that's where the segregation comes into play. That what are the different types of legal research? What do you when will be classified as a certain kind of legal research? Okay. So here what we are dwelling into is some key categories. However, there are different types of legal research depending on what is your fact and how you are progressing with it. But the key categories are these, which we are going to discuss in our session today. Primarily is a doctrinal research. It's a black letter research. What you do in doctrinal research is you already have a notion or a topic in your mind. And what you do is you analyze it by the virtue of what is existent. You know, like during our discussion, you just said that we would go online to look for it. Okay. So you are actually going online and looking from whatever primary or secondary sources are available. Okay. By virtue of those sources, you're actually analyzing the statutory provisions and the cases. The second category is entirely different from the first. It is a non-doctrinal research. In this research, what you do is you go on ground and investigate what the law is and to what extent it is going to impact the society. This category of research is mostly done in socio-legal scenarios. Let's say today I want to know that how is the judicial infrastructure affecting the pendency of cases in the Indian legal system. So what I'll do is I'll go on ground, go visit every court that are within my reach, and I'll look what are the aspects that may end up affecting the case's pendency. And thereafter, from that drawing, all that aspect is the legal research that I'm undertaking. And from that drawing, I'll come to a conclusion. So that process of research is non-doctrinal research, which is also synonymously called as empirical research. Now, third most pertinent form of research is reform-oriented. In this category of research, what you do is you evaluate the existing laws and systems and you access whether they are suitable for as per the current laws or rules or not. So you're looking, okay, this is the legal system that's existent, okay, and now you'll see whether it is suitable as per the needs of the society or not. Okay, these are the laws existent. Now I'll look into whether they are, as we were talking about the reformation of the criminal laws. So the reformation came into play because there was a reform-oriented ideology that the existent laws were age-old. Therefore, the need occurred and reform-oriented analysis were undertaken. And thereafter, they were reached at a conclusion that yes, there are gaps in the law and therefore there is a need for reformation. So these are the three categories of legal research. Another categories are theoretical research, wherein you just let's say you want to talk about what are the different child rights, or let's say rights of a woman who's working in a workplace at companies. So to do so, what you're doing is you have to undertake a descriptive study. You have to go forward by looking in the definition of working woman, what are the concepts, what is the concept of a company, and then you have to see what is the relationship between the two, on what notions the relationship comes into play. So all those descriptive study, the conceptual and theoretical analysis to establish certain legal principle is undertaken when you conduct a theoretical research. Now, another category is conventional text and articles. Whenever you undertake a case study, let's say you have similar as your moot court competitions, you're undertaking a case study, you're doing an in-depth analysis of what are the related articles or text, though that's an hypothetical scenario, but even during that duration, you are undertaking a thorough study, which is one of the type of legal research. Another category is empirical research. It is very similar to non-doctrinal research. A certain category of tools that are employed while undertaking it, that may include observation, interviews, and survey. Whenever you employ interviews or questionnaires in order to learn what is the status of a certain question at law, or let's say fact, then you undertake those questionnaire and you establish or you come to a conclusion. Now, moving on to the second aspect of our session today, what is a legal writing? A legal writing involves analysis of fact patterns and presentation of arguments that in documents such as legal memoranda or briefs may reflect. So what legal writing is a process. Once you've undertaken a legal research, now you have to imbibe it in a writing and in such a persuasive manner that the receiver understands that how your legal stand is justified. So legal writing is very relevant because it is actually involving an analysis of the fact pattern that you undertook, and thereafter how you're presenting those arguments. So even though you have great clarity while you were undertaking the legal research, however, when you are putting it down into the legal writing, you're not that articulate. So your legal writing would not come out as you expect it to be, or it may not bring out the objective or the main mindset that you had when you undertook the legal research. So legal writing holds equal importance as legal research. So there are different forms of undertaking legal writing that involves when you're drafting a legal instrument, or when you're drafting a legal document that are contracts or wills. So all of those writings are legal writings, and they're more persuasive only when there is a certain directed or there is a tone that's set right at the beginning. When you're undertaking the research, it should actually corroborate with what question you had in mind. The objective should not be lost. So legal writing should be very articulate. So moving forward, after we've undertaken a good research which holds relevance and which looking into its importance, we've now dwelled into what is legal writing. So legal writing becomes relevant. Why? Because it is important to articulate or put through our legal research objective, and it can be characterized as something that makes or that substantiates our query as being accurate. The way that you write a legal writing, it should be very clear. Only then the accuracy can be established. So it should be based on what is the demand. Let's say hypothetically you're undertaking a legal writing for your institution. It must be abiding by the rules that are laid by the institution. Or moving forward, if you're writing it in a court, you're filing, let's say, a case, even then it should be as clear or as at par with what are the laid guidelines. So it should have that level of clarity and accuracy. Only then your rightful message is being put through. And it should also be very concise. It should not be free flowing. It should be accurate. It should not be, if you have to talk about an apple, you're talking about its color, stem, tree, branch, whatever. No, it should only be talking about the query, the process involved, the actions undertaken, and what are your conclusions. So these are the few stages that becomes very relevant all through your legal research and legal writing. Now, Now that we've understood what is legal research and what is the relevance of legal writing, now what are the sources that are involved in order to gather the data for legal research or for legal writing? So some primary sources are, or that includes laws, rules, regulations, bylaws, ordinance, or case laws, and some secondary sources that may involve legal commentaries, abstracts, dictionaries, scholarly articles, encyclopedia, etc. So these are the different sources from where you can gather information, and that may help in corroborating your argument, or that may help you in gathering more information to substantiate whatever stand you may hold. Thereafter, this is the last part of our discussion today. Here we'll be talking about what is an ideal format of a legal research report or a general research report. So what I've tried to list down is a pattern that an individual can follow when they're undertaking a research right at the beginning of from an article to moving forward to articulate their legal arguments. So I'm not saying that these are very concrete and exhaustive list. This is just the flow that you may follow that may help you dwelling a good research report. So primarily, it's very important that you have an introduction. The introduction, it gives a more context and general background of why you're undertaking a research or why is the research relevant. To do so, you do a few literature review. Literature review is, unlike we've been talking about since the start, to search. So the process of search is literature review. When you're going through a particular book, you're going through a particular article, what you're doing is you're reviewing different literature. So once you've had a background, you've had a query, thereafter you did some studying that falls into literature review, and that's when you've established, okay, this is the problem, this is the research problem that I'm trying to look answers for, or this is the problem that I will conduct my research on moving forward. So now after you have had a research problem, now you have an objective. The objective is that after I resolve this research problem, certain aspects will be achieved or certain objective will be reached out. All right. So then that is the fourth step that should be in your mind, that, okay, ultimately, what is the objective that is in your mind? What is that you're trying to gain out of the entire process that you're undertaking today? Okay, I want to know whether there are any laws for breaking traffic lights or not. So first, what I'll do is I'll look into what is the general introduction, what is the general background that's there. Then I'll look into different laws that are existent. That becomes my literature review. Problem is that there is no law. Objective is that there should be some law. Now, the next very important step that comes into play is research question. Now, the question is why? Why exactly, if the scenario that we were discussing, we talk about it, why exactly do we need a traffic law? So that is the research question wherein we get stuck upon. So then that is the stage wherein once we've had the problem, we have a question. Now we have a hypothesis. The hypothesis is quietly related to our objective, that, we're presuming that if we have traffic lights that or traffic related rules that may help in lessening the level of accidents that are in the current scenario. Okay, so my that is my hypothesis, and my objective is that it lessens or relaxes the traffic policies or helps the consumer at large. Okay, now moving forward, what I did was I undertook the research. It can be doctrinal or non-doctrinal. Either I go through the available data that's there, or I go and undertake the research as per my own ease. Okay, that's up to the researcher whether they want to take the first-hand information or they want to come to conclusion from the secondary sources. Both the ways works. So then there is data collection. If you're going through the primary process, you're employing the non-doctrinal ways, you'll go for the data collection. Once the data is collected, the data is analyzed. Irrespective of the source, primary or secondary, data analysis is undertaken. this is done in light of the research question that we have and the research problem that was substantiated. Then there are discussions. Discussion is, we'll see what are the discussions around, and thereafter we would also during the analysis come to a discussion to with the queries that we hold by the people around us, or maybe, you know, just by looking into what's already there existent. So that gives a this is a brainstorming part wherein you are trying to dwell into what all other aspects could be existent, and thereafter by all this process you prove your hypothesis. Once your hypothesis is reached, I mean, sorry, prove, either you prove it or you don't prove it, you reach to a hypothesis. So thereafter you give a conclusion, you provide some recommendation that aligns with what objectives you had, and thereafter you would quote a few references that you've used. In the references, you can mention on what all you know, books that you went through during the literature review. So that goes here. Using this format, you can, you know, prepare either a proposal or article or a report. So this format will be really handy for those who are trying to undertake a legal research or a legal writing. For somebody who's generally willing to understand how to progress into legal writing, they may also follow this 11-step research report format. Not heading by heading, but definitely in spirit, in order to be more articulate and structured while undertaking a research. So that is all from my end. And if anybody has any question, we'll be happy to take them. So yeah. Anybody?
Now the participants can raise their hands one by one and can ask to ma'am any of their queries. Like, first of all, you have to raise your hand and then proceed further. Okay, ma'am. So some people are
Hello.
writing their queries in the chat box. So
Hi, ma'am.
for answer, if that works.
Hi, ma'am. Hello.
Yes, Satya. Hi. Please go ahead.
Ma'am, this is Dhanunjay actually. Okay. My
Yes,
name
sorry.
maybe it was showing Satya. Okay. Ma'am,
Yeah.
actually, I'm trying to write a research article from the last few days, but I'm having some ambiguity that how to start the re. I know that how to start and everything, but while I am putting my thoughts into the paper, I'm not conveying the exact way how I want to write an article. And can you suggest any tip, ma'am, like for my improvement
So,
of writing a research article?
okay, so I think what is important is, Satya, that you primarily, if you want to get started how to write an article, first you need to have a topic in mind. That's very primary. I mean, you cannot just write about, let's say today you feel more passionate about the recent criminal laws that were introduced. So what you'll do is, an ideal way to go about would be that, you know, you have a topic, you go online, look for that, what is the new law that was introduced. Okay, now let's say you want to write an article on this. So first you will read about what the law is. Now you will see the differentiation in the previous law and this law. Okay, so now what you're doing is you're comparing. Okay, now in order to bring out a good article, it is important that, okay, you have a query, what is the existing law. It's also important to understand why was the law introduced, what was existent before, and why was the need felt, and what is introduced today. So once you have a very a good structured article, I think that's the key to go forward with it. And that is one thing, when you have more, when you read a lot, you know, as law student and with so much of AI being around us, we tend to take reading very lightly. So however, that's very important. Once you get started, you read, and you read well. that's when you yourself will be in a position to structure how to go forward with it. So I think that would be my answer to it, that read more. And then once you read more, you're coming across a different articles, you're coming across a different books that are already written. So once you go forward, you would, have an understanding how to progress forward.
Sure, ma'am.
I think
Thank
we
you, ma'am.
have
Yeah,
yeah,
thank you, ma'am.
my pleasure. I think we have a few questions in the chat. I'll go one by one. Is India Qanun reliable? Yes, Indian Qanun reliable, and it's really helpful in order to get case laws. So definitely a go-to platform. How much time does it ideally take to prepare a research paper? A good research paper may take 2 to 3 months, depending on how much hour you're devoting in a day. So that becomes very pertinent. How can we remove plagiarism from legal research? That is only when you rework it. So that's the only key. You can only remove plagiarism when you don't do it. So that is the key. Hi ma'am, please tell me about writing footnote and references. For writing footnote and references, Mithilesh, it's actually there is no straight jacket formula for it. Okay, that this is how you should footnote. In fact, every institution has their own format of footnoting and references. What is important is, please use legal platforms like Loctopus, like LawSikho, which has descriptive article about how to go about it, how to, what are the different categories of footnoting, what are the different types of existing, prevailing footnote styles. So once you're aware of those styles, it becomes easier, because the Oscula may ask you to write date in the end of the footnote. However, once you go by other formats, it may not, right? So what Blue Book may not. So it is important that you be aware of different styles of footnoting. So that way it becomes easier. Okay, so Sonam says, how should I search for relevant case laws? For relevant case laws, the best way is to go by citation. Always go by citation. Let's say there is some case which citation is AIR 2015, AC 14. Go by citation. If you don't get the citation, then please use the names only within the inverted commas. That will definitely help you. What is the difference between research article and a research paper? Research article is a brief that you talk about, not very vast of a difference. Article is just when it's a very small analysis of a particular topic that comes to your mind. It may not be backed by stronger sources as compared to research paper. Research paper is well drafted, structured, and mostly backed by some primary or secondary sources that the author undertook in order to come to a certain conclusion. How can I find research gap in doctrinal research topic? It's very easy, because you need to compare the topic. Let's say if you're talking, if you're looking for telecommunications, what were the laws that that are there for incoming calls? Then you have to compare what was previously. It's always better to compare two scenarios. Whatever query you have to look for, was this always existent? If not, why was this introduced? And if it was it's a fresh law, then what was there before? So there is always a comparison that helps you to find research gap in doctrinal research, because it's more theoretical in nature. How to prove a point in argument when the law is not made on that? What references to use? See, there are certain times that there are laws directly not available on a certain argument. However, there are always corroboratory laws that are there. So long we've been talking about the traffic lights. Let's say hypothetically there are no laws for traffics, and there are a lot of accidents. So then the cry is that we need the law. What to do then? So what we do is, our argument is based by what are the let's say the vehicular act, that is also corroboratory, very important for the traffic rules. Thereafter, we go by the human rights, that is also very relevant. And third and foremost is comparison. Once you compare it with the other countries' laws, you compare it with US, UK, Australia, and you come to a notion. So basically, the jurisprudence of an issue. Any issue at in play has a history to it, has had a discussion. If not here, somewhere or the other, if nowhere, there are always, you can be the first person to talk about it, and that you do by undertaking non-doctrinal research. So that's one way to do it. Monica, how to analyze judgment? Do I need to always read the ratio of the judgment? If I'm not wrong, Manu Patra and SCC online, they have the ratio of the judgment. That gives you most of the clarity. This is not a one-day job. It will take you years to understand. At least if I am supposing you are in your third year, fourth year, you will have better clarity how to read a case law as compared to somebody who's in first year, because you need to read a lot of case laws in order to understand what is the breakdown. So I think that is something for reference. What you do is, please go online, look for material available for these national law universities or Delhi University. So they have a very elaborative case studies. Once you get a hang of how exactly a case law is dealt, that is when you become more aware of how to reading it without having the effort to read it in entirety. So that's that. For improving research data interpretation and analysis skill, what should I be doing? I think what is important is that you have to read a lot of research reports. Once you read, let's say, Niti Aayog did a research on cases pendency. So what you need to do is you need to read that how did they reach a conclusion. Once you read that and you keep working on your own individual skills, that's when you will be able to improve yourself. So I think that's the key. And yeah, what are the ways to enhance better legal writing? I think the best way to enhance is, once your research is well defined, the legal writing is not a big play. There is always a set format as per the requirement. If you're undertaking a legal writing for a court, there is already a set format. It primarily depends on what research you've undertaken. If your research is well drafted, well undertaken, it's always the case that your legal writing will be articulate. So I think that is there. And always, it's always better to ask around. I think we as a generation have not accepted the fact that we do need people around us. So it's also good that you ask your seniors, go get a copy of what is a set format and learn from it. It will always help you. When I know and stop myself, when read and find material for, when I know and stop it, when read and write material for research literature. I am sorry because I didn't get you well. Are you asking that when to stop when you're undertaking a research? Please write Y or N if I'm wrong. Okay. Okay, so that's a very good question, because that is something that I also tend to fall into, because once you get started undertaking research, because internet is an ocean of information, you keep dwelling. So I think what helps me the most is, I always time bound myself. I would not go on, I'm not on a spree to find an answer. That's for sure that I have to get. What I always keep in my mind is that I'm looking for something. If it is there, then the information will be readily available. If it is not there, I have to look for it, and I can dwell in to an extent. So that's something that I would suggest is, if the topic is extremely niche. However, I strongly also believe that you tend to get a lot of information that's related. So if something is extremely niche, it is important that you restructure yourself or restructure your research approach and keep it time boxed. So that really helps. Thank you. Anybody else?
So If there are no queries from anyone, so can we proceed with the vote of thanks?
Yes, please.
Okay, so ma'am, can we wait for like just a minute so that if anyone is having a query, they will be typing in the chat box or
Sure,
asking.
sure.
Yeah. So I assume that there are no further. Okay, so there is one query for you, ma'am. How to avoid
Yeah,
plagiarism while writing a paper?
just one suggestion, Satya. Don't cheat, don't use a plagiarized word. The only way to avoid is rework it, redo it. That's the best way to write, because see, once you get a hang of copying and pasting, see, it never helps you because you're obviously taking credit of someone else's work. So the best way to do is to not do it, and rework it, restructure your you can always um, change the format from active to passive. You can always give credit, so it's important to give credits. Always use either mention the author's name or put it in inverted commas, give credits. So that's the best way to go about it. And if any one of you has more queries, I am on LinkedIn. Please feel free to reach me out there. I would be, quite available there. So you can always connect there and come forward with your queries. I'll be happy to help. Thank you. Happy New Year to all. Okay, what should be the ideal number of research questions? Okay, the ideal number would be 3 to 4. More than that, I think if you have, you should be ready for the hard work. I would not limit the level of research question. It depends on how big of your research is or how big of a research query that you have in your mind. So it is highly dependent on what research approach you're undertaking or the research query you have. So yeah, thank you. Thank you all.
So, ma'am, moving forward with the session, as I hope everyone, the queries which were arising by the participants, so might have been cleared. And so, ma'am, finally, I would like to thank you for giving your valuable time for each and every one of us, and sharing your valuable insights for us related to legal research and how to proceed with our jobs related to legal research and legal writing. So I think that this session might have played an important, like this session might have acted as a booster for many of us who all are having, like who all are in their initial years, who might be in their first or second years to start with their career with legal research and writing. And at last, I would like to thank you for having an interactive session with all of us through the Legal Innovation platform. And ma'am, yeah, thank you so much for sharing your valuable insights with us.
Thank you. Have a very
Thank
good
you,
evening.
ma'am.
Happy New Year. Thank you. Thank you so much. Thank you.